do you see where I'm kind of frustrated? If you're going to pay for an attorney, you should pay for the lots of fines and fees and restitution and other things that you owe from 2010. You're right to hire an attorney, but I don't know why you wouldn't qualify for a public defender. I don't know any of those things, but you owe a lot of money. We're set today for a plea and sentencing. Ms. Hanu, is this matter going to proceed as such?
It is, Your Honor.
Okay.
For the court and for the record, I was previously appointed in Mr. Hubbell's case, and then I withdrew. It was not due to a conflict of interest or a breakdown in attorney-client relationship. That was simply an administrative matter. I advised Mr. Hubbell of the same. The current offer is to plead to operating while intoxicated, a second offense, for a joint recommendation of a $976 fine, 5 days in jail, and 12 months of a driver's license revocation.
All righty. And so how much jail credit does he have?
1 day.
1 day.
Jail credit?
Yeah, there would be a request to allow Mr. Hubbell to serve that time on the monitor. He advised me he would intend to prepay that, obviously. He is currently employed. He just does not currently have the finances. He'd be asking for a little bit of time to prepay that.
Okay. Sorry, I'm just pulling up the plea questionnaire right now. I'm sorry, I had a message from somebody that I needed to respond to, and I apologize for that interruption. Can you just repeat the agreement that's been reached?
Yes, Your Honor. The agreement would be that Mr. Hubbell would plead guilty to OWI second offense. There would be a joint recommendation in line with IDIP guidelines, as Mr. Hubbell has completed IDIP for 5 days in the county jail, $976 in fines and fees, and a 12 months driver's license revocation. There would be an additional request joint recommendation for Mr. Hubbell to be able to serve the remainder of that time on electronic monitor.
But he needs time to prepay it. It would only be like $75 for the monitor. Or are you thinking prepay the whole fines and fees and things?
I was thinking the monitor, but
Well, it's an OWI second, so I can give you time to report, and that's really not a big deal. And with regards to the fines and fees, we can get into that in a bit. Okay, so the IDIP guidelines, and you did the IDIP, and how did you find it, Mr. Hubbell?
everything went good. I mean, I was already sober at that time, so, but, you know, just having somebody to talk to like Dave, he's a really good guy. And he also shared his experiences with alcohol with me. And
you know, you can reach out. Dave would allow you to like stop and say hi, or maybe
yeah, I seen him at the Webster Fair.
He is an absolute great, wonderful man.
Yeah, he is.
And he does really great, wonderful things for our county. And
he does a lot with kids and the troubled kids.
Kids all the way up to elderly, I would say he is good with and works well with. So
yeah, I also want to let you know that I am still going to Aurora.
Excellent. Yes.
Yeah, I'm still doing my appointments there, even though I'm all done with everything. Just, it's good to follow up on the stuff.
It really is, especially with your family history and all of those things. It is good to continue with that. You may not have to do it as frequently. I don't know what your frequency is, but it's good to continue to do that because you have made some amazing strides, Mr. Hubbell.
Yeah.
Okay, so I do have in front of me the plea questionnaire waiver of rights form. Did your attorney and Ms. Hanu did state that even though Ms. Sherwood is listed as your attorney, she's had you previously, or she was on there with Ms. Sherwood or helping her out at the time.
Yep.
And she did go over the plea questionnaire waiver of rights form with you?
Yeah.
And did she go over it all with you, essentially word for word?
Yes.
And do you remember everything? Do you understand everything thoroughly?
Yep.
And that is well, I have an electronic signature right here. We're gonna have to print it out. And then you are going to need to sign that. So if you want to come up here, get the document, review it, make sure that's what she went over with you, and sign it, please.
Use the pen at the table. Apparently all of our pens are.
Sign over here and date it.
Where?
You can just sign it
Over here.
under your name.
Unless that pen doesn't work. We have secondary.
All right. And that is the document that she went over with you?
Yep.
And now you have signed it. So you're pleading guilty to an operating while intoxicated second. You've completed the IDIP program and you're asking the court to follow the recommendations, and that's the agreement for those sentencing guidelines, correct?
Yep.
You're 33 years old. You have a high school diploma or equivalent. You can read, write, you understand the English language.
Yes.
Other than substance abuse treatment, no other mental illnesses or disorders or treatment?
No.
No alcohol, medications, or other drugs today?
No.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that first page, and your attorney thoroughly went over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around April 13th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under an intoxicant, the influence of an intoxicant on a highway or roadway of this county and state?
Yes.
Do you understand that this would be a second countable offense?
Yes.
And do you understand that upon conviction, that for the second offense within 10 years, you shall be fined not less than $350, but no more than $1,100, and imprisoned not less than 5 days, but no more than 6 months?
Yes.
Do you also understand that the court shall order an OWI AODA assessment and follow through,
Yes.
and shall revoke your license for not less than 1 year, but no more than 18 months?
Yes.
Now, do you understand that there is an agreement that's been reached in which the court would follow IDIP guidelines? Do you understand I'm not bound to follow that?
Yes.
I could sentence you to the maximum possible penalty if I thought it was warranted.
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over that criminal complaint with your attorney? And I'm talking particularly that probable cause section where it basically said what happened that day and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did operate a motor vehicle while under the influence of an intoxicant?
Yes.
And it is your second countable offense?
Yes.
Ms. Hanu, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney and Ms. Sherwood, have they both represented you competently?
Yes.
Have they both answered all of your questions?
Yep.
They went over whether or not you have any defenses or any lack of defenses?
Yes.
And are you satisfied with their defense?
Yes.
Do you have any questions for this court or for your attorney before I proceed?
No.
As to count one, operating a motor vehicle while under the influence, second offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it
Yes.
means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. The remaining, well, actually count two and count three will be dismissed and read in. Count three will be dismissed and merged in with count one. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Avila.
Thank you, Your Honor. I believe the joint agreement here is appropriate. Mr. Hubble has completed the IDIP guideline, as the court previously noted. But more specifically, the court's well aware of Mr. Hubble's background. It's aware of his journey with substance abuse, and specifically, it's also heard already how much the IDIP guideline had a positive impact on him. And it sounds like he's going to continue to follow up with that moving forward. I think the sentence also achieves the goal of specific and general deterrence, specifically deterring Mr. Hubble from re-engaging in these patterns of behaviors that led him to this point. If he decides to operate while under the influence again, he's going to face harsher penalties. And general deterrence, as in letting the community know that these do carry mandatory minimum sentences should people continue to drive while under the influence. Regarding the need to protect the public here, his license is going to be revoked for an extended period of time. I think that goal is satisfied. As such, I would ask the court to adopt. Thank you.
All right, Ms. Hanu?
Thank you, Your Honor. I believe that this recommendation is more than appropriate. The Intoxicated Driver Intervention Program is meant to allow people who are charged with OWI to work and put in the work to achieve a recommendation like this. Beyond that, Mr. Hubble has maintained employment since the death of his father. He is the caretaker of his grandmother. He is sober 8 months. And on top of that, he took himself to inpatient recovery to deal with his substance use issues. As the court has heard, despite no longer being in the IDIP program, he continues to seek AODA treatment, and he has shown that he will put in the work, he is putting in the work, and he will succeed. I'd ask the court to adopt the recommendation.
All right, thank you. Mr. Hubble, anything that you want to add or you want to say?
Just that, I already told you that I'm following up with all this stuff, and I don't want to see you again, no offense.
I don't want to see you either, no offense. That's it?
I learned my lesson.
Mr. Hubble?
I've been through some tough stuff, especially like, the passing with my dad, and then the guy was my best friend, spent almost every day with him. But I just came to a point where alcohol just wasn't it anymore.
I'm very glad to hear that. I'm so glad to hear that.
I hit it really hard after he passed, I put myself in treatment and got better.
You continue to get better and better and a better person inside and out with each passing day, Mr. Hubble.
Yeah.
You and I remember our first meeting, the first case. It wasn't your best shining moment. And I'm so glad to see that you've worked through that, especially with the mother of your children, because that was a big issue there.
Mm-hmm.
And it sounds like, at least from the character reference that I read some while back, that both you and she have worked together, and you've been a present father, and you've been there for the kids. You've been there for her, even if you're not together as a couple, and you've stepped up.
Yeah.
And I am so glad to hear that and to know that that is happening. And you and I both know I've seen your dad in court for similar issues. But I'm going to tell you, he too had that aura about him of being a good, down-to-earth human being.
He was a really good guy.
And
he'd give you the shirt off his back.
I could get that feeling from him. His issue as well, I mean, it was the alcohol.
Mm-hmm.
And I don't know where that started from. I don't know. Genetics is a part of it. It usually runs in a family. It could have been grandpa, great-grandfather.
Yeah, his dad, my grandpa, was an alcoholic. And then, I don't know, I guess it just traditions.
Here's the deal. You get to make your own traditions with your kids now, and it doesn't have to be focused around alcohol.
That's the plan.
You have a graduation party, you don't need to have alcohol. You have a birthday event, you don't need to have alcohol. Just because we're born and raised in Wisconsin and in Burnett County, we don't need to have alcohol at every celebration or other event.
Yeah. It went from Busch Light to Diet Coke now.
Well, boring is good.
Yeah.
And you're in this spot where previously, and especially after your father's passing, you were a risk to the community.
Yeah,
And you did engage in some very, very ill thought out actions and
Right.
conduct.
I don't deny any of it.
But now you've gained a better understanding. You've taken control of your substance abuse disorder. You've taken control of what it does mentally to you. You've taken control of what it does physically to you. You've taken control of being a father and a co-parent. And those are good, positive, wonderful steps. And I want you to continue to do that. And so I do think that the guidelines here are appropriate. I do have to ask you, with this, there are 25 hours of extra community service.
I had already talked to,
Tessa?
yeah, oh, not Tessa, the place in Webster.
So you're going to do the community service?
Yeah,
Great.
Yeah.
That makes me happier.
I already told them I was gonna be back because they told me that I was gonna have 25 hours there.
Well, that's good to hear, because sometimes people just want to convert it to extra jail time or being,
No, I don't
You know.
like jail.
so that's good. So what I'm going to do is follow the recommendation, $976 in fines and fees, plus a $10 blood draw fee, 5 days of jail, 1 day of jail credit. You will be able to get good time. So 5 days with good time is 4 days. With 1 day credit, you have 3 days. 12 months ignition interlock device, 12-month revocation of your driver's license with credit for any administrative suspension you may have already received because of this.
So that would cut the time to 0, right?
I'm
Because
not
I
sure.
lost my license right away, right? It's been over a year.
Yes, it could be if the Department of Motor Vehicles did put that administrative suspension on you, then by getting the credit and doing what you need to do, you can at least work towards getting an occupational sooner.
Okay, does the occupational have to have interlock?
Yes,
It does, okay.
it does. Any vehicle you drive for the next year must have an interlock.
Okay,
So, and you need to have a vehicle registered in your name
Mhm.
with the interlock for at least that year. So do you believe or think that you can pay off that fine, the fines and fees in one, or do you need a payment plan?
I will probably need a payment plan, yeah.
Okay, I'm gonna order $200 a month, and that's going to start in August, can be your first payment. I'll let you get all situated with jail and the monitor. I will give you the ability to serve the remaining jail time on monitor. It's house arrest. You can go to work. You can go to the grocery store. You can go to church. I would time this wisely because you can't go to the beach with your kids. You can't, go to a graduation party. You can't do any of those things. It is house arrest for a reason. But like I said, you only will have 3 more days to sit and be confined. The rest, you're going to do community service, 25 hours. I'm very glad to hear that. I will give you 30 days to figure out when you want to sit that time. So 30 days to report. And when you decide to do that, you'll just have to let Dave or Tessa know. And then they'll have a monitor ready for you. You'll go get booked in. You'll be released to either go right to work or to go back home. It does monitor your alcohol and other substances. So make sure that you are not around any gasoline with it. So don't accidentally
Gas?
spill. Yep, anything could set it off because there's alcohol in rubbing alcohol. There's
Oh.
alcohol in mouthwash. So if you accidentally spill it on the monitor, then it'll set it off and it'll say you need to immediately report to jail. Okay, so
Yep.
I'd be very cautious for 3 whole days while you're on the monitor, right?
Yep,
So Tessa and or Dave will go over the other rules and policies with you as it relates to that. But as you probably know, I'm a pretty strict judge. So if it says that it registered alcohol, even if it's 0.001, you will be told to go to jail. No good time, no Huber. Okay.
yeah, you won't have to worry about that.
So I'd be very, very careful. And I'll do it. So,
Yeah,
but I'm so proud of you. I really am, Mr. Hubble. And to be honest and to be blunt, and right before you even walked in, I had a brief conversation with both the state and your attorney. You are a wonderful guy. You have a great heart. And you do project that. When you allow alcohol to take control of your life, it clouds all of that. And this
Yeah.
is the best Mr. Hubble to see. And imagine breaking the cycle of alcoholism with your children and what that means for your future and their future and your grandkids.
That's the goal.
That is the goal. And to be a present dad and a good co-parent, even if you're not together, a good co-parent that works together for the better of the kids.
Yeah, our relationship has been really good
So glad to hear
ever
that.
since.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, I will issue a warrant. You could sit up to 6 months in jail. I need your fingerprints, at least it says I do, and I do need your DNA. So when you're
I
done
did
here,
fingerprints.
they did do
Yeah,
fingerprints?
yeah.
Then it's just, sometimes it lags in my system. So I do need your DNA. Do you think that you're gonna report sometime soon or?
Yeah, within the next 2 weeks, yeah.
Okay. I'm fine if you want to wait on the DNA when you report, just make sure you says Hanu, I do have a waiver of preliminary hearing filed in the electronic case. Did you thoroughly go over that document with Mr. Cote?
I did, Your Honor. We reviewed everything on the document, as well as time if Mr. Cote had any questions.
All right, okay. I am gonna tell you, and I'm gonna tell you on the record that, again, I don't know how other courts do the things, because sometimes we talk. I do need an actual signature on the documents, either with the prelim and with a waiver of prelim, as well as the plea questionnaires, those kinds of things, just for the future. But for today, it's fine. Mr. Cote, did your attorney go over this document with you where she went over what a probable or what a preliminary hearing is and the burden of proof, as well as what it means when you waive that right to have that preliminary hearing?
Yes, she did.
And so did you give her the permission to electronically sign your name on your behalf today?
Yes,
And so do you understand that once you give up the right to a preliminary hearing, it's forever and you can't get it back?
yes,
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
no,
You're doing so freely and intelligently. That means you are telling me you fully understand what you're doing
yes,
and you're doing so voluntarily.
yes,
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set it for another date, Ms. Hanu.
We can proceed with arraignment, but I would request 10 days to be reserved on pre-arraignment rights.
Yes. Mr. Cote, it's the same, the information has the same charges as that original criminal complaint, okay?
okay.
It mirrors that criminal complaint. So at this time, does he wish to enter not guilty, please?
Yes, Your Honor, not guilty, please. And just so the record is clear, I did inform Mr. Cote that following this hearing, an information would be filed and it would likely mirror the criminal complaint, of which he is aware of what the 13 counts are.
All right, okay, great. So not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you still on Church Road?
Correct.
And your telephone number ends in, yes, it does. We have the correct one. Can we send you text messages if we need to?
Yes,
Okay, all right. We can set this for another date. You have 10 days. Extension, Ms. Hanu.
Thank you, Your Honor.
And I just have to double check who filed this, Mr. Vila. So. It's gonna be a while because we are
Booked and busy, Your Honor.
busy. August 5th at 2:45.
I'm in jury trial that day.
Are you?
I'm in jury trial the next day too.
About August 3rd at 2.
For a status,
Yes, just a status.
if I could appear virtually and if Mr. Cote was okay with it, I could make 2 o'clock work.
I'm fine with that, but just so you know, if you do need Mr. Feliski to fill in, he should be in front of me at that time too, and it would just be a status.
Oh, perfect.
So,
You know what? Somebody will be here.
all right, so August 3rd, 2 o'clock.
Does that work for you, Mr. Cote?
Yeah, can I appear over the phone or do I have to be in person?
I'm fine if you're over the phone, just as long as you appear and you appear on time next time, okay?
All right.
All right. Anything else?
Nothing for me.
Then we're adjourned. Thank you.
Thank you, Your Honor.
Mr. Rogers, can you hear me?
Yes, I can.
Attorney Becker, can you hear me?
I can hear you, Judge.
We will go on the record in the matters 26 CF 27, 26 TR 199, State of Wisconsin versus Lee Rogers. The state appears through Assistant District Attorney Jose Vila in person. We do have Mr. Rogers appearing by telephone conference with approval of the court. We have his counsel, Michael Becker, or he's not listed counsel, but he is making a special appearance on Mr. Rogers' behalf. We're set for an arraignment. Mr. Becker, Attorney Becker, were you able to go over the criminal information with Mr. Rogers?
Your Honor, I believe that Attorney Lundin did go through that information with Mr. Rogers prior to today's hearing.
He understands charges and maximum penalties, Mr. Rogers?
Yes.
Any waives formal reading, Mr. Becker?
Yes, we do.
Not guilty plea?
Correct, Your Honor.
A guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I can get a status set on a Mr. Schmidt week. Attorney Schmidt,
It is his case, Your Honor.
yes, week. I can do August 13th at 9:15, and Zoom and telephone is approved again if you wish, Mr. Becker and Mr. Rogers.
Yes, please.
I believe we would appreciate that. Thank you, Your Honor. Did you say 9:15 on the 13th?
Yes,
I believe
August
that would
13th.
I believe that would be okay. Thank you.
All right, August 13th at 9:15. All right, anything further?
No, Your Honor.
Not from us, Judge. Thank you.
All right, thank you. Then we are adjourned.
Thank you.
Have
Have
a
a
good
good
day,
day.
All right, Mr. Schaaf and Mr. Chapman. We will go on the record in the matters 25 CF 64, 25 TR 291, 292, and 293, 26 CF 51. State of Wisconsin versus Sean Shaw. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Schaaf, who is appearing in person with his counsel, Daniel Chapman. We're set here today in these matters for status conferences as well as a preliminary hearing. This matter is proceeding as a preliminary hearing in 26 CF 51. Mr. Vila, please call your first witness.
Thank you, Your Honor. The state calls Officer Tyler Hoagland.
Officer Tyler Hoagland. I think this is the first time I've seen you up here testifying. Please come forward, raise your right hand. You're going to be sworn in and then come have a seat over here on the witness stand.
You swear that the testimony you're about to provide today for this matter is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may begin.
Can you please state and spell your name for the record?
Tyler Hoagland, Tyler, last name Hoagland, Hoaglund.
And how are you currently employed?
I'm employed with the St. Croix Tribal Police Department,
And how long have you still been employed?
6 months.
And prior to today's hearing, did you review a criminal complaint in Burnett County case 26 CF 51 as it relates to Sean Schaaf?
I did.
On April 16, 2026, did you conduct a traffic stop at the intersection of Lake 26 Road and Minerva Road?
Yes.
Is that area located in Burnett County?
Yes.
Why did you conduct the traffic stop?
I conducted the traffic stop for no illuminated license plate lights.
Did you make contact with the driver?
I did.
Who was the driver?
Sean Schaaf,
How'd you identify him?
his Wisconsin driver's license.
Do you see that same Sean Schaaf sitting here in the courtroom today?
Yes.
Could you please identify Mr. Schaaf by where he's sitting and what he's wearing?
Yes. He's sitting in the right chair there in a looks like to be a t-shirt, a gray t-shirt, black t-shirt.
The record reflect that Officer Hoagland has identified Mr. Shaw.
Was anyone else in the car?
Yes, there was what appeared to be 3 children under the age of 16.
Did you speak with Mr. Schaaf?
I did speak with Mr. Schaaf.
What did you talk about?
I was just conducting a simple traffic stop. I collected his the proper identification, his insurance, and then I kind of went about my day is to running him through our tribal dispatch system, and at that point, I mean, I approached his vehicle again and observed his eyes seemed to be glossy, and the vehicle smelled like it was emanating an intoxicant from the vehicle, which is why I conducted my OWI investigation.
When you say conducted an OWI investigation, what did you do?
I asked Mr. Schaaf to step out of the vehicle and to stand in front of my patrol vehicle. And at that time, he complied. He got out. I asked him how many beverages he had. I can't remember the exact amount he said. He said that he had some Busch Light. And I just simply told him that I would be conducting just some standard field sobriety tests to make sure he's okay to drive his vehicle to his destination that he was traveling. At that time, I conducted the standard horizontal gaze nystagmus, the walk and turn, and the one leg stand.
Did you notice any clues on the horizontal gaze nystagmus?
Yes, I did.
How many clues did you observe?
I don't quite recall.
Okay. The next test you conducted was the walk and turn, correct?
Walk and turn, yep.
Did you notice anything there?
Yes, I did.
What'd you notice?
I noticed that when he was walking, he was unable to keep his feet when he was walking. He was unable to keep his feet heel to toe like I instructed.
Mhm.
And I don't recall. I believe he took the wrong amount of steps. But I can't completely remember on that.
And the other test you conducted, what was it?
It was the one leg stand.
Did you notice anything there?
Yes, Mr. Schaaf was unable to keep his balance through the duration of the test, and he was swaying.
Okay. What'd you do after completing the field test?
After completing the field test, I asked Mr. Schaaf if he was willing to submit to a preliminary breath test, and he declined wanting to do that. And at that time, I placed him under arrest for suspicion of operating under the influence.
Now, did he submit to chemical testing of his blood?
Yes, he did.
What were the results there?
I don't recall. I just got the blood tests back and I just issued the citation not too long ago. I don't recall what the reading was, but I do know it was above the legal limit.
Okay. So you said you placed him under arrest for operating while intoxicated.
Yes, sir.
Does he have any prior convictions for operating while intoxicated?
Yes, he does. To my knowledge, I believe he has 4 of them.
Okay. And at the time of this incident, was Mr. Schaaf on bond?
No, he wasn't. He did explain to me that he had court for a similar offense the following Monday.
No further questions, Your Honor.
All right, Mr. Chapman?
Were you wearing a body camera that night?
I was.
Was it active the entire time you were communicating with Mr. Schaaf?
Yes.
And does your squad car have a camera on the dash?
It does not, no.
Okay. Did you ever investigate the tail or the license plate lamp?
I did look at the license plate lamp and as well as the other officer that was on scene.
And what did you see?
It was not illuminated.
Okay. And you said Mr. Schaaf declined to blow into the preliminary breath test?
Yes, sir.
No further questions.
Any redirect?
No, Your Honor.
All right, your excuse, thank you.
Thank you.
And I will be moving to admit a copy of his driving record and evidence.
All right.
Thank you.
Any further witnesses?
No, Your Honor.
Any witnesses, Mr. Chapman?
Just want to double check this. No, Your Honor, no witnesses for today.
Any argument, Mr. Chapman?
No, Your Honor.
All right. Based upon the testimony of Officer Hoagland, the court does find that there's probable cause to believe a felony was probably committed in Burnett County, and it was probably committed by Mr. Schaaf. Therefore, the court will find the probable cause and bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I am in the process of filing the information. It will mirror the criminal complaint.
Proceed with arraignment or set it for another date, Mr. Chapman? He's having surgery, is he not?
Do you know when that is?
The 29th, I have it scheduled for
The
July.
29th, you have what?
Surgery scheduled.
Okay,
Do you remember what the arraignment was? That's just where we plead not guilty.
Yep.
So we can do that today.
Yep.
He's saying the charge is going to be the same as what's in the
Okay.
criminal complaint.
Yep.
And you just have to know if you wanted to change judges, but if you didn't do that last time, there's no reason you
Yep.
want to this time. We can do the arraignment today, Your Honor.
he understands the charge and the maximum penalty, or charges and the maximum penalty.
He does, Your Honor.
Waive formal reading.
We will waive reading of the complaint and plead not guilty to the 2 counts.
Not guilty plea will be entered on his behalf. He is entitled to a jury trial. You would be entitled to a speedy trial should you request one. We need to get the matter scheduled for a status. You're having surgery on July 29th. And did your doctor give you an approximate amount of recovery time?
Not really, but he said I'll have to have a catheter for 2 months.
And this is a Mr. Schmitz.
It is, Your Honor.
September 10th in the morning, Mr. Chapman, or
One moment.
afternoon, whatever is easiest for you that day, if it works. Oh, you are coming here on that date anyway. at
Yes, I am.
9 o'clock. 9 o'clock on September 10th. Okay, hopefully, I mean, that gives you, wait, oh, I was going by today, July 29th. Off the record, I have had people here with Casper's before, but he can appear by video conference or telephone or something like that if you wish to do so.
Yes, Judge.
Okay, back on the record, both may appear by video conferencing or telephone if it works better if you don't have good internet capability. Okay, Mr. Schaaf. So we'll get an new defense counsel in person with Mr. Strenke. We're set today for a status, but we had forewarned notice that this could potentially be a plea in sentencing, and that is what it is. Ms. Hanu, do you have a plea questionnaire waiver of rights form?
I do, Your Honor, if I may approach.
You may, please. Thank you.
Your Honor, to recite the agreement,
Thank you. Sorry, I was just trying to figure out how much cash we have.
no worries, Your Honor. The joint recommendation by the parties would be for Mr. Strenke to plead to an amended count 1 of simple possession of methamphetamine without the repeater for costs. And if, as we get to the argument stage, I can further relay to the court why that would be the case.
All right, and that's the agreement, Mr. Strenke?
Yes, Your Honor.
Mr. Vila, that's the agreement that the state has reached.
Yes, Your Honor.
Formal motion to remove the repeater,
So made.
granted. Mr. Strenke, I have in front of me the plea questionnaire waiver of rights form. Do you recognize this document?
Yes, Your Honor.
Did your attorney thoroughly go over the document with you,
Yes, she did, Your Honor.
word for word?
Yes, Your Honor.
You understand everything on that document,
Everything, Your Honor.
and that's your signature?
It is my honor, Your Honor.
You're pleading guilty to possession of methamphetamine simple, 36 years old. You can read, write, you understand the English language with a high school diploma or equivalent. All correct?
Yes, Your Honor.
You are going through AODA treatment?
Yes, I just got enrolled, but it's been a work in progress, but it's you know, I'm trying to get stuff paid for and make sure I stay up on my child support and everything. So it's been, but it took a little while to get the $125 for the initial assessment, but yeah, I finally got it. So I start classes next week. So
All right. And that's really good to hear. It's only $125?
yeah, because I had a recommendation from probation. I asked them, I said, well, I said, man, I said, I can't do 250. I was like, I said, can you meet me halfway or something? I was like, I said, I'm not fighting the fact that, you know, I have an issue. I was like, I'm trying to get help, but I was like, I just can't go back to my old ways to do it. I said, so
I'm glad it cost you less. I'm glad you're not trying to go back to your old ways to get the money to do it. And I'm glad you are enrolled in substance abuse counseling and treatment.
thank you, Your Honor.
All right. And so did your attorney thoroughly go over your constitutional rights with you?
She did, Your Honor.
So and you understand all of those rights?
I do, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that once you plead guilty, you're waiving and giving up those rights?
I do, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I do, Your Honor.
Do you understand that here the state would have to prove on or around February 23rd, 2026, you possessed a substance. The substance was a controlled substance, methamphetamine, and you knew or believed that substance to be a controlled substance, methamphetamine. Do you understand what the state would have to prove?
I do, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
I do, Your Honor.
Do you understand that the recommendation, a joint recommendation to the court for a sentencing option would be costs only? But do you understand I'm not bound to follow that?
I do, Your Honor.
I could sentence you to that maximum penalty if I thought it was warranted.
I do, Your Honor.
Now, did you go over that criminal complaint with your attorney? And that's that original charging document where it basically says what happened that day and why you were charged with the crime. You remember that?
Oh, yeah, I vaguely remember, but yeah,
February 23rd, when you possessed a substance, the methamphetamine, and a summary of what has occurred. You're looking at the document right now.
yes, Your Honor.
And so looking at that document, would you say that for the most part, those facts alleged there as it relates to possessing that methamphetamine, they're accurate?
Yes, Your Honor.
Ms. New, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Strinky, for you
No,
to
Your
plead
Honor.
guilty?
I'm sorry.
Okay. You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing
I do, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
She's answered all of your questions.
Yes, Your Honor.
Has she looked at this matter thoroughly?
Yes, Your Honor.
Are you satisfied with her services?
I am, Your Honor.
Any questions for the court or your attorney before I proceed?
No, Your Honor.
As to the amended count 1, possession of methamphetamine, simple, how do you wish to plead?
Guilty, Your Honor.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights, what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. Judgment of conviction will be entered today. Mr. Vila, argument.
Thank you, Your Honor. Mr. Strinky is here taking responsibility for his actions. This is a substance abuse issue that reared its ugly head, unfortunately for him. He seems to realize that he does need to pursue treatment. As a result of this case going the way that it did, he did receive a DOC sanction for 30 days, and he is still going to be on he is going to be on probation for at least the next 18 months after this case is concluded. As such, I think costs are the more appropriate option for this case. Thank you.
Ms. Fanu.
Yes, Your Honor. As a result of this, Mr. Stranke did sit a 30-day sanction with recommendations from probation to enter into AODA treatment. As the court has heard, he has worked very hard to get the money and actually get that set up and is following through. He has his appointment next week. Is for protection of the public. He is going to be on probation in another case for at least 18 months. I think also not putting him on more probation saves resources and saves time for people who may need more supervision than Mr. Stranke. Mr. Stranke is employed, he is working, and frankly, Your Honor, he looks great. He's doing really well. I think cost is appropriate here. Not only is it another felony conviction on his record, but there is fines and fees, and he is employed and he will continue to be employed.
All right, Mr. Stranke, anything you want to add? You want to let me know?
I just wanted to apologize for not being punctual, missing my last court date, and I really intended to be here, and I just wanted to apologize on that end and everything to everybody, because I hate wasting anybody's time. So, and yeah, it was just some miscommunication on my end, so I apologize. So.
Well, Mr. Stranke, I'm glad to see you here and apologizing. You're taking responsibility not only for the possession of the methamphetamine, but for your failing to come to court and messing up and owning it. So I appreciate that. I know you. I don't know you super well. You've only been in front of me, I think, once or twice, maybe.
Yeah.
But yeah, you're a hard worker. I remember that.
Yeah.
And it sounds like you are trying to get everything in place and to put the yellow brick road there so you can follow it and you can take charge and you can take control of your sobriety.
Yeah.
Because you're the only one who can do that. I'm very glad to hear that you were able to get the AODA assessment at a reduced cost. I want to say I'm glad that you're on probation. I'd rather you not be on probation. But that'll come, and it'll come with more work and harder work towards your sobriety. And hopefully you're going to be able to do that and find your path and just hit it hard and continue with your AODA assessments and treatment. Have you been to any inpatient residential treatments?
Yep. So last year around November, I think, is when I went to the BART house up in Barnett. So I went up there, and then I did it's supposed to be like a 70-day program. I graduated in 55 because one of the fellow classmates or whatever they call them, you know, I mean, like bunkmates or whatever, you got in an altercation with the guy that comes in or that did come in and do AA, you know? So like he'd come to the bar house and do AA on Fridays, and for some reason this dude had a problem with him or whatever. They got in an altercation. Well, long story short, I just took over running AA, you know, so I graduated like 12 days early, and you know,
That's great.
I mean, I figured I'm be there anyways, you know, for the duration. So I was like, well, there's no point in making it so nobody can graduate, because I mean, that's part of the curriculum. So I was just like, well, we can piss and moan about it all we wanted, but you know, unless somebody steps up and does something about it, it ain't gonna change.
That's great that you took charge, you took control, and you went above and beyond. And that's showing me and telling me that you can do this. You just have to get back to those things that you learned, and back to the sharing and expressing that with other people, the back to going to the AA meetings and or leading your own. Because the more you're involved, the more your sobriety, you'll take charge, and it'll solidify, and you won't have to worry about methamphetamine controlling you anymore.
Yeah, when I started doing the AA group, like the night that I got in that altercation or whatever, there's like 2 guys that came out of 10, and I was like, I said, what better do you guys got to do besides come down and talk about our addiction for an hour? I was like, I mean, besides the fact that you're gonna still be here if you don't. I mean, for one, but I said, we all have issues or whatever. I said, it's not like we have to make it a topic meeting and make it by the book or whatever. I mean, like, obviously you kind of go through the 12 steps or whatever, but it can be whatever's on your mind, you know, and then that could be the thing that keeps you from relapsing, you know, is just having somebody that's willing to talk to you about it or listen.
That is definitely right on point, Mr. Strinke. I'm really proud of you, and I'm proud of the steps that you're taking.
Thank you, Your Honor.
I think that the agreement is appropriate, so $500 cash. I'm gonna sentence you to 30 days of jail. That's time served. You said it.
Okay.
You might as well get the credit for it, right?
Right.
So I'm sentencing you to 30 days, time served, $500 cash. You have that posted, you're good to go.
Yep.
Because you missed court, so you had to post it.
Yep.
Well, actually, I'm waiving $18 actually. So then we're all good to go.
Okay.
You don't have to worry about $18.
Thank you, Your Honor.
You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. You're pleading to a felony. As such, you can no longer use or possess a firearm for life. I do need your DNA. So when
Okay.
you're done here, you're gonna need to go to the jail and just make sure that they
Okay.
have it. And so they'll swab you if they don't. If
Okay.
they do, they'll send you on your way.
Okay.
You have the right to request it be expunged through a written letter to the Department of Justice, the Wisconsin Department of Justice, not to me or the court, okay?
Okay.
Talk to your attorney or Google it. It's very easy to do. 30 days jail credit. Am I missing anything, Mr. Vila?
Did the court provide the rights to appeal already?
20 days to appeal.
Perfect, and nothing else, Your Honor.
Nothing else, Your Honor.
All right, then we're good to go.
All right. Thank you, Your Honor.
Congratulations and keep it up.
Thank
It's
you.
gonna be hard. You know it.
Oh,
You know
yeah.
it will, day by
Yeah.
day. Keep it up.
Hey, what doesn't kill?
Can you hear me? I cannot see you. There you are.
Hi, Judge. Yes, thank you.
We will go on the record in the matters 26 CM 64, 26 TR 307, and 308. State of Wisconsin versus Roger Peterson. The state appears through Assistant District Attorney Jose Vila in person. Mr. Peterson appears in person with counsel Joel Larimore making a special appearance on his behalf by video conferencing. We're set for a status conference. We do have a financial review hearing somewhat kind of scheduled. I didn't list all of the cases. It's a lot of cases. It's a lot of money, Mr. Peterson, that you continue to owe for very old matters. I believe most of it is restitution. And so we do have to address that. And I know that you did make a small payment last month, and I think you were making a payment today when you were coming. Is that correct?
Yes, I did.
How much were you able to pay today?
30.
Okay, you need to kind of step that up. You're just gonna
I know.
need to step that up.
I'm
Because-
trying.
I'm not sure, and I'm gonna try and go to find your case. I didn't bring in all of the paperwork, but it's significant. Where are we? I can't even remember which cases because there's quite honestly a lot. Okay, here we go. Well, there's one for 7,400 and some dollars. I think the total is around 12 grand though, or something. If I'm recalling off the top of my head though, that's what I'm recalling. And so, and again, we're going way back from, and what I'm looking at with this 7,500 almost is from a 2010 case with lots of 2010 cases on there. So there's a lot there. So you're going to have to ramp it up just a little bit more because $30 a month is not going to cut it. And I can't take that anymore. I know that you're working and I know that you're still at Gone Green and I know that you're trying really hard and you need to pay for your expenses and do all of those things. However, people, victims, the state, the county, they do need to be paid back for those kinds of things too. I'm like, you know me, I'm good with waiving interest if we need to do something like that, waiving other fees that are not mandatory. However, you have to do other things such as community service and those things to be able to get benefits like that. Because we want to get you up and get you, you know, paid off so that you don't have to keep having me hound you all the time. Okay. And so we're here now for this other matter and these other two tickets. One is a theft, a misdemeanor theft, and then the two tickets are possession of open intoxicants in a vehicle and operating while suspended. So Mr. Larimore, you are taking this, or you're at least here making a special appearance on Mr. Peterson's behalf?
I am making a special appearance, Your Honor. It's my understanding that he's going to retain me. And so I was hoping the court would allow me to make that special appearance.
And you can, and do you see where I'm kind of frustrated? If you're going to pay for an attorney, you should pay for the lots of fines and fees and restitution and other things that you owe from 2010. You're right to hire an attorney, but I don't know why you wouldn't qualify for a public defender. I don't know any of those things, but you owe a lot of money. Okay. And now we have this theft and we have these other two tickets. So has an offer been made, Mr. Vila?
There is, but before I continue, I do want to let the court know that we did hear from the victim. There is going to be a restitution request that comes in. There were items that were missing from the vehicle. So just wanted to flag that for the court.
We have an idea or no, none really? None really. Okay, so I don't know. I'm not going to have you tell me any of the facts or anything as it relates to the case from your standpoint. I'm going to have you talk to Mr. Larimore. But if there are things that Mr. Larimore and Mr. Peterson, if there are things that you know, oops, didn't get back in a car or do some of the things, you should work with your attorney to try and figure out how to get those things back because you have the right to go to a trial. You have the right to have the state prove your guilt beyond a reasonable doubt, or the jury can find you not guilty. You have all of those rights and all of those things. But there sounds like there may be a restitution hearing if this matter gets to that point of a finding of guilt in either by a jury or a court trial or by a plea. Okay, so work with Mr. Larimore with that. And then again, let's just jump down and say all of those things happen, boom, boom, boom. That's going to be more restitution. That's going to be, that's more that you're going to have to pay the court. That's more of all of those things. And I'm going to have to start coming down a little bit harder to try and collect all of the thousands and thousands and thousands that are owed, Mr. Peterson. Okay.
Yeah.
Right. Okay. So what was the offer?
The offer was 1 year probation. However, that was until I knew there was a restitution request. So depending on what that number is and what those items are, the offer is likely to change.
Okay. All righty. So Mr. Larimore, anything you want to add? You want to state? You want to let the court be aware of?
No, not this time, Judge. If we could set it for a status conference in approximately a month, I'm hoping we can get things moving forward.
I could do August 5th at 9:45, and you may appear by video, Mr. Larimore.
That works, Judge. Thank you.
Ms. Bauer, do you think we can have an idea? It doesn't have to be specific, but just a general idea if you talk to the victim of what potential restitution could be?
Yes, Your Honor.
I think that would give us a little bit more of an idea of where everything is headed. Okay, Mr. Peterson, talk to Mr. Larimore. The state, Ms. Bauer is going to try and figure out what is allegedly missing and the values of those things, so we know what an offer could be and where we could go. I will see you August 5th. You can come up here and get your notice, and then you are free to leave.
Thank you.
Still working, gone green, nothing else has changed?
Yes, I'm still there.
But are you full-time?
Yes,
Okay, are you gonna try and get in some community service here and there?
I've tried a little bit, but with Caring Hearts, but it hasn't worked.
I would try harder.
Okay.
And with interfaith, try harder, because it needs to be somebody like that that says on this date and time, Mr. Peterson did this for this many hours, signed by the nonprofit director, person in charge, okay? Because that'll go a long way to me looking at all of that amount that you back owe to try and see if there's something that we can at least get off of your debt, okay?
Okay.
All right, thank you.
Thank you.
Thank you, Judge.
Thank you, Mr. Larimore.
Good morning.
I assume my client, Mr. Ryan, will be brought over so I can have him sign the written waiver form. Is that?
Probably not. If it's a waiver,
Oh, well then I have the written waiver form. I suppose I can run it.
nope, that's totally fine.
All
I'm
right.
totally fine with all of those things. You did all of the things I need you to do, and if he will be by video, they may bring him down unless they didn't know it was gonna be a waiver.
All
So either way, we'd be good to go, but the fact that you even went over that with him,
That's fine.
amazing.
All right.
So we're good.
We've already met, Your Honor.
Perfect.
I want to put on the record that although the waiver is independent,
Mhm.
that we have an agreement for the minimum
Mhm.
mandatory is concurrent.
We will go on the record in the matter 26 CF 72 and 13 CM 347. State of Wisconsin versus Spring Staples, also known as Jay. We have Jay appears in person with counsel, James McLaughlin making a special appearance on Jay's behalf. The state appears through Assistant District Attorney Jose Vila. We have, and Victim Witness Coordinator is here as well. I guess we don't need her for this case, but she is here and present. Do we need you for the disorderly?
Not for the disorderly.
Okay, all right. So Jay, you've had an opportunity to talk with Mr. McLaughlin, who is a very experienced attorney, and he's pro bonoing, just talking to you about the case, and he's went over everything with the possession of THC, which it was charged as a second and a felony, correct?
Yes,
And did he go over with you that you can have what's called that preliminary hearing for the court to determine if a felony was committed and if it was committed by you?
yes,
And so do you understand that you're saying here today you wish to accept the offer by the state, which is to amend to a simple misdemeanor possession of THC? Is that correct?
yes,
And so you're waiving your right to have that preliminary hearing?
yes,
Has anyone made any threats or promises to you for you to waive that preliminary hearing today?
no,
And so you have had enough time to think about if you want to accept this offer and enter a plea to a misdemeanor?
yes,
Okay, so I will find that you are freely, intelligently, and voluntarily waiving the right to a preliminary hearing. So based on that, I will find the probable cause, bind the matter over, information will be filed, but you wish to accept the offer, and I have a plea questionnaire waiver of rights form. Do you understand, or do you recognize this document?
yes,
Is this the document that Mr. McLaughlin just went over with you?
yes,
And it indicates you're pleading guilty to possession of THC marijuana as a misdemeanor, correct? And you sign this document?
yes,
Do you understand everything on this document?
yes,
And the recommendation to the court is for costs only, and you understand that?
yes,
And so you're 39, you understand, speak, read English, is that correct?
yes,
No mental illnesses or disorders for treatments, no drugs, alcohol, or medications?
no,
Did Mr. McLaughlin go over your constitutional rights with you?
Yes,
And did he go over them thoroughly with you?
yes,
Do you need me to go over those with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up these rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand the state would have to prove on or around May 11th, 2026, you possessed a substance, the substance was a controlled substance, THC, and you knew or believed that substance was a controlled substance, THC?
yes,
Form a motion to amend to a misdemeanor?
So made.
And do you understand that the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
yes,
Do you understand the recommendation is for costs only, but I don't have to accept that?
yes,
I could sentence you to the maximum penalty if I thought it was warranted.
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Now, are you admitting here today you in fact did possess THC
yes,
and you knew it was THC marijuana?
yes,
Do you have any questions for me or for Mr. McLaughlin before I continue?
no,
Before he makes his plea, may I make a brief statement, Your Honor?
Please do.
Attorney James McLaughlin appears pro bono publico and an officer of the court. He's appearing as Attorney McLaughlin from Rice Lake, Wisconsin, and not as a private attorney. I have one on the record that Mr. Staples and I met this morning. I have not had an opportunity to review discovery. However, he has told me that he read the complaint, that I told him that no complaint is perfect, but he did tell me that there is a factual basis for the charge and the adjudication, meaning that it's true that he possessed marijuana. No one forced him to, it was intentional, and that the state would have to prove beyond a reasonable doubt that he intentionally possessed marijuana, and specifically, according to recent law, as I understand it, that they'd have to prove a certain Delta 9 component of marijuana. And he told me that he understands that. He's read the complaint and he wishes to enter in the plea agreement. He and I discussed that he does not have to enter into this plea agreement, that he had the right to preliminary hearing that the court went through, but that he views, and I, in my professional judgment, believe that if it is truthful that he possessed marijuana, there is tremendous benefit to the agreement that is being proposed to the court today. Thank you. That was the record I wanted to make.
All right, thank you. Any questions or anything you want me to know?
no, Your Honor.
There's nothing else. So as to the simple possession misdemeanor THC, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the misdemeanor version of the THC possession. 13 CM 347 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I believe cost is more than appropriate in this matter. It is a simple THC possession case. Furthermore, Mr. Staples is taking full responsibility for his actions and has decided to wrap up this case with a very quick disposition. As such, I think it's more than appropriate, and I would ask the court to adopt.
All right, thank you. Jay or Mr. McLaughlin?
I concur with opposing counsel's remarks. I think he summarized the matter succinctly and professionally.
Jay, anything you want to add, you want to state?
No, that I just take full responsibility for the charge and it won't happen again.
I appreciate that. All right, this is not a very serious matter. You are taking responsibility and very quickly. So what the court is going to do, I'm going to assess $500 cash. You have that posted in bail. You're good to go. I do have to order that you provide your DNA. You'll go to the jail when we're done. You'll just make sure that they have it. You'll be able to request it be expunged from the system through a written letter to the Department of Justice. It's easy to do. You can Google it. You don't ask me, you Google Wisconsin Department of Justice with the DNA. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right, okay? I believe that covers everything. You are good to go. So when we're done here, again, make sure that you go and that you provide your DNA, okay?
The only thing I would like to add to record, Your Honor, is that as the court stated, he has 20 days from today's date to, he obviously is appreciative of the results here today, but should he change his mind, he has 20 days from today's date to seek relief to the Intermediate Court of Appeals. My phone number, which I will write down for him, but I'll put on the record, is 715-651-6181. That's my private line. Services of his attorney McLaughlin, continue through those 20 days. Thank you.
All right, thank you.
I met this morning.
All right, we will go on the record in the matter 26 CF 10, State of Wisconsin versus Stephen Ronning. The state appears through Assistant District Attorney Jose Vila in person. Mr. Ronning appears in person in custody with counsel James McLaughlin. We're set today in this matter for a preliminary hearing. However, this will be a waiver of a preliminary hearing. I've just been handed the waiver of right to preliminary hearing document. Mr. Ronning, is that accurate and true? You wish to waive your right to a preliminary hearing?
Yes,
Do you recognize the document I'm holding up right here?
yes,
And that is the waiver of right to a preliminary hearing. Did your attorney thoroughly go over that document with you?
yes,
Do you understand everything completely?
yes.
Do you want me to read or go over your rights with you as it relates to a preliminary hearing and waiver? Or do you understand them as they were presented to you by your attorney?
I understand them as they were presented to me by my attorney.
And that is your signature on this document?
Yes,
Are you waiving your right to a preliminary hearing freely, intelligently, and voluntarily?
yes,
Has anyone threatened you to do so?
no,
All right, I will find that you're freely, intelligently, voluntarily waiving your right to a preliminary hearing. I do find probable cause and find the matter over. First off, though, do you understand that once you give up the right, it's forever and you can't get it back?
yes,
All right, information, Mr. Vila?
Thank you, Your Honor. I have the information. It mirrors the criminal complaint.
Proceed with an arraignment or set that for another date?
No, we can, Mr. Ronning, we have discussed that at the arraignment, one deadline is the deadline to request judicial substitution, in plain English, get a different judge. We've talked about that, right?
yes,
And that you decided not to seek judicial substitution. Is that correct?
yes,
Therefore, Your Honor, knowing that the information will be a different document that would mirror, meaning be identical to this, except it'll have the word information on it, are you therefore comfortable, as I am, proceeding to arraignment immediately?
yes,
Therefore, we waive any formal reading, Your Honor. We acknowledge that the information is identical to the complaint which he has in front of him. It is a 2-count complaint / information. We are prepared to enter a plea.
All right, so you want to set this for,
A plea. We will enter not guilty at this time, Your Honor. And we would ask that this matter, I would put on the record, the waiver of preliminary hearing was independent of any consideration. However, the parties have reached an agreement in which they will be recommending to the court the statutory minimum penalties for an OWI 7th or consecutive. With Mr. Ronning, you understand the court is not bound by any such agreement. You understand that?
yes,
And we've talked about that.
yes,
And the court could sentence you up to the maximum consecutive with any other sentence you might be serving. Do you understand that?
yes.
All right. That having been said, Your Honor, we would ask that the matter be set for plea and sentencing at the convenience of the court and opposing counsel, and hopefully on a day that fits what the court knows is my schedule.
yes.
This is technically Mr. Schmidt case.
Thank you.
If
That
you
makes
want
it
to,
so much easier.
whatever week you want to schedule it, we'll.
That'll
take
be
care of it,
next
Your
week.
Honor. Okay.
It's either next week or September.
Next week sounds great, Your Honor.
I'm sure my client would like next week, and let me try to accommodate him, because I can almost feel the energy off of him asking me to come next
Well,
week.
I
And
want to make you happy, Mr. Ronning.
if I was in his
Make
shoes,
me
I would.
happy to put that bottle down.
I wish I could, I honestly, truly wish I could help you with that.
I'm here, I believe, on Wednesday, the 15th at 11, if my memory serves.
Oh, I cannot. The only time I can give you is Monday, the 13th from 10:30 on, or the 14th.
Let me, according to CCAP, I start in Washburn at 1:30. And so what I'm going to do, and I can do very early in the morning, and I will being here for him is more important than my handling Washburn intake. So I can do that, or I can do later in the day. I have a Washburn juvenile at 2:30, so I'd look to the court's guidance as to which I should do.
All I could give you is 10:30 until noon,
Yes,
or the 14th at 1.
the 14th at 1 actually serves me better.
Okay, the 14th at 1.
I can prioritize this.
We'll do a plea and sentencing, but here's what I'm gonna do and what I'm gonna need.
This is Mr. Ronning. You're gonna need a plea questionnaire waiver of rights.
Correct. And I don't know you. You're from Minnesota, right? So this is, I believe, the first time I've ever seen you in my life.
Yeah,
I don't recall having you in the last 8 years. So what I'm gonna need to know, and what you're gonna need to do, is give your attorney some history, or be prepared to tell me your history, because this is an OWI, operating while intoxicated, 7, 8, or 9. That's a big deal. And I'm going to tell you right off the bat, it's a big deal to me. And I know it's a big deal to Minnesota because you're in prison there, and that's why you're here now, is to be sentenced on this, and you were revoked in Minnesota because of this.
You have a 20-year-old burglary, is that right?
Hmm?
You have a 20-year-old burglary?
Yeah.
All right, Your Honor, the court knows this is off the record. You know, my motto is cards face up. It's been my professional motto my whole career. I understand, and his history is almost entirely in Minnesota, that he has a 20-year-old burglary, and otherwise he has a series of drunk driving convictions that are essentially his significant criminal record, like no domestic abuse, things like that. He has the burglary and a series of criminal convictions that make him arrive in front of you with this charge. That is, but I will gain, and I will urge Mr. Schmidt's office. We don't have NCIC, but I will use my investigator to corroborate whatever his statements to me are.
Okay, because I'm going to say the history, that would have been my guess too, just mostly the alcohol driving related issues. I want to know about you, Mr. Ronning, what your life was like growing up, why you believe you have a substance abuse disorder with alcohol, when your last conviction was, and why treatment, what treatments you've engaged in, and what you believe you think you can do better to start to change your life and to, as you said under your breath, to take that bottle away from you, to help you remove that bottle. That's what I'm going to want to know. Okay.
And let me again continue my theme. If I was a jurist and I thought the minimum mandatory incarceration was reasonable concurrent, but that I wanted additional extended supervision for public protection, defense counsel would understand that. So therefore, the plea agreement would be for minimum mandatories, but I don't think that Mr. Ronning poses an immediate threat given the sentence he's serving in Minnesota, but his demonstrating to the court his conviction of sobriety in the future going forward will be our theme. And I think he's even evidenced it here today.
All right. And so I'm also going to want to know what your sentence is in Minnesota, but your attorney will tell me those things, or you will, or somebody will at the sentencing. Okay. I'll see you on Tuesday at 1.
All right, Mr. Ronning, my client service specialist, whose name I gave you, Miranda McLeavy.
The judge looked at the defendant, then said, "Put that bottle down." The courtroom instantly fell silent. What started as a routine court hearing quickly turned into a powerful conversation about addiction, responsibility, and second chances. The defendant was facing his 7th OWI offense, a case serious enough to carry mandatory prison time. Before discussing a plea agreement, the judge wanted to know something far more important. Not just what crime had been committed, but why it kept happening. The defendant's attorney explained that his client had spent years battling alcohol addiction. Most of his criminal history wasn't violence, it wasn't theft, it was one alcohol-related offense after another. The attorney admitted that his client was already serving a sentence in Minnesota and wanted to resolve this Wisconsin case by accepting responsibility. Instead of rushing through the hearing, the judge stopped everyone. He